We are live, sir.
All right. Good afternoon, everyone. My name is Ashish Bhardwaj. I'm Dean of Jindal School of Banking and Finance and one of the directors of JIRICO, which stands for Jindal Initiative on Research in Intellectual Property and Competition at OP Jindal Global University. On behalf of JIRICO and JGU, I welcome everyone to this round table this evening. I would like to acknowledge the presence and the efforts of my colleague Aviru Bose, who's assistant professor at Jindal Global Law School, key member of JIRICO, who will be moderating this discussion as the curator of the program, along with Ms. Sangeeta Singh, who leads the Economic Advisory Services in EY India. We have a phenomenal group of panelists who've joined us today. I would like to thank each and every one of them for their time, their presence, and they'll be sharing their insights in the discussion, which will start very soon. I'm thankful to EY for partnering with JIRICO for this very important roundtable. And again, Ms. Singh for her leadership in helping us put this event together and for being a moderator with Aviru. I remember Sangeeta spoke in the Global Finance Conclave 2 years ago. This was, of course, the pre-COVID era, where I think she talked about the role of women in driving economic growth. And it was received very well. Thank you, Sangeeta. Thank you, all the panelists, once again. I want to start by, and of course, we have our founding Vice Chancellor, Professor C. Rajkumar, who will be delivering the inaugural address very soon. Thank you, Raj, for being here. Before I say a few things about the topic of our roundtable, I want to say that the year 2020 marked the 5th-year anniversary of JIRICO, 5 years of promoting the idea of innovation, the idea of competition for shared prosperity of people, nations, and markets. And we have done this through dedicated research, through collaborations, through several training and capacity building measures. Since 2015, I believe we have published more than 120 journal articles in peer-reviewed journals, books which have been downloaded thousands and thousands of times, book chapters, opinion pieces. We've organized more than 30 conferences, panel discussions, moot competitions, workshops, seminars, all of which were open to the public without any fee, as is the case with all the events that we host at JGU. One key takeaway from these efforts, this consolidated efforts of JGU, is that we realize that scholars, judges, academics, lawyers, economists, even policymakers across the world, including India, are usually divided along ideological and even party lines when it comes to the topic of regulating and trusting the big tech companies. Well, they mostly seem to agree that while the degree they hold is really of an elite tech company, if you go into the details, the transcript reflects rather poor grades in terms of anti-competitive behavior. And this is something we're going to be talking a lot about. And there have been different responses around the world. Breaking up firms as a drastic measure, as voiced by a few sections of the society in the US, is certainly an obsolete solution now. It simply won't work in a digital age. And now that the elections in the US are over, the new Congress, I'm sure, is going to take up these issues very quickly. Last month, even the Chinese regulator surprised everyone with a Christmas Eve present of antitrust investigation against the giant Alibaba. So that was a surprise. Europe has been consistently considering tougher regulations and sanctions. In India, however, the Competition Commission, under the able leadership of both past and current members and advisors, has been graduating from an almost non-interventionist approach to a very nuanced case-by-case assessment, thereby adopting a cautious yet flexible methodology in cases concerning digital markets. In fact, the study which was commissioned by CCI, the market study on e-commerce in India, was a great initiative to examine the dynamics of digital marketplace and its impact, particularly on smaller vendors that consists of pretty much make the backbone of Indian economy. Now, I remember a sentence from a popular Netflix documentary called Social Dilemma, that if you are not paying for the product, then you are possibly the product. And unlike the nature of anti-competitive behavior of the traditional large brick and mortar industries, the anti-competitive concerns with the new age digital businesses are in fact quite different. In some cases, it is the freebies that cause maximum damage. In the early internet giants certainly realized two very important things early on. One is, of course, that data is valuable. We've heard that many, many times in the last few years. But second, and more importantly, because they found data to be immensely valuable in the future, they could use a business model based on free and close to free offerings to scale very quickly by luring customers with little or no traditional level of customer acquisition friction. But now, tech companies, startups, vendors, regulators, financial institutions are realizing how important it is to understand the dynamics and challenges of markets that are very digital in nature. Some experts have been hailing the DLT, distributed ledger technology based blockchains, as a very effective solution to provide the way out of the issues of inefficiency, corruption, security of data, eliminating the middlemen, delays, and so much more. But that's going to be, I hope, the topic of one of our future JIRICO roundtables. But this is a very important topic, and the others are going to reflect on it a lot. What I've also realized that regulators don't have to necessarily act or react in the way that others have, especially the Americans, the European regulators, how they have reacted to some of the situations. The Supreme Court judgment of last year endorsed that the Competition Commission of India performs the very pivotal inquisitorial role of being a guardian of market competition and consumers rather than performing an adjudicatory role, but it does act in the interest of the public and the markets. There's a strong belief that market competition and a very well functioning, oiled marketplace are not only the basis of protection of consumers, but it is a time tested incentive towards innovation and progress. Finally, it is very hard for any one of us to ignore the undercurrent of strong but narrow sentiment of tech nationalism, which is pretty much reimagining the entire dilemma of dominance and monopolization of digital markets as a foreign versus domestic debate. In digital markets, potential risks of anti-competitive behavior remains the same, whether it's global big tech, local big tech, or global big tech. And I'm sure this roundtable will bring out a lot of new perspectives on these issues in discussing India's digital reset, as the topic of this roundtable stands, as conceived by Sangeeta and Aviru. And this is happening as our industries and consumers ride the big wave of digitalization that seems to be aligned with the vision of the current Indian government of a self-reliant, technologically connected, and digital-first India. With that, I invite our founding Vice Chancellor of OP Jindal Global University, Dr. Raj Kumar, to deliver the inaugural address. Professor Raj Kumar has not only led JGU to heights, greater heights and accolades, he's been instrumental in getting JGU the coveted recognition of an institution of eminence, which was awarded to us last year by the Government of India. Foundations of JIRICO are in fact rooted in his vision, his leadership, and his ability to see opportunities where we really saw hurdles. Over to you, Raj.
Thank you, Ashish, for a very generous introduction. And what an extraordinary time when we have all come together once again under the banner of JIRICO. And of course, thank you to our partner, EY. Thank you very much, Ms. Sangeeta Singh, for your leadership and for your contribution towards forging this collaboration. I am very excited to be part of the panel discussion on India's digital reset, the role of regulators in times of COVID-19. I also want to take this moment to thank my colleagues, Ashish Bharadwaj, Indranath Gupta, and Avirup Bose, and others who have contributed to the creation of this initiative in the form of this panel discussion. I see very familiar faces, including our very good old friends, Dr. Geeta Gori. I thank Professor Daniel Sokol, Mr. Ashutosh Kumar, Dr. Anuj Kumar, Ms. Payal Malik for joining us, along with Mr. Manas Kumar Chowdhury for joining us in this panel discussion. Of course, I wish we had done this on our campus. I look forward to welcoming all of you to our campus sooner than later. In some ways, the ongoing journey that JIRICO had begun in the year 2015 I vividly remember in 2016 we had JIRICO's first international conference. Early conversations surrounding innovation and technology and digital transformation was pioneered by the JIRICO in the form of bringing together people from India and around the world. And several conferences since then have been hosted. And along the theme that has, of course, now gained greater prominence due to COVID, but JIRICO has provided with academic and institutional and thought leadership in bringing all of us together. So I'm once again, I would like to congratulate my colleagues, the three initial musketeers, Vishwas, Indra, and Ashish, but also others who joined along with Avirup and Manveen and many others who have been part of JIRICO. I also want to say that one of the things that we are facing today in the world is with regard to how regulation can catch up with innovation and digital transformation. And at one level, uh, most of the world has been immensely benefited by the digital transformation that we have seen. Where we sit in academic institutions, uh, I would like to say that from the month of March, we have been completely pursuing online education. No student has walked into the campus, but yet we have conducted all our classes online. We completed our examinations, graduated the 2020 batch. We admitted students to an entrance examination through our AI-enabled remote proctored examination system. And of course, we brought together the new batch of students, and then we are well into the start of the new semester on 1st of February in an online mode. Imagine for a moment this advancements in technology had not happened, we would have obviously lost these 9 months. But more importantly, even with this, we consider ourselves a more privileged institution. A large part of the world, good part of India as well, is completely deprived of this opportunity when it comes to having access to technology in having this. Of course, there are other areas in which the digital transformation has helped including in the fields of e-commerce, communication, and in travel, transportation. I mean, there's not a single sector in which the digital, reimagination has happened. Digital transformation has not touched. Of course, all through this, the fact remains that most part the regulations have been relatively meek, timid, and at times, not necessarily understanding and appreciating the full impact and import of what has happened. Even in advanced countries such as the United States, it had to see through significant scandals for congressional hearings and Senate hearings to happen to make the big tech accountable, but more importantly, even for those in public policy to understand what this technology is about and what kind of impact that it has with regard to the world of commerce, society, privacy, ethics, and governance. So, in some ways, the role of regulators is going to be the most critical and central question that we will continue to ask, and there is no better organizations well suited in the form of JIRICO and JGU and JGLS on the one hand, and Ernst & Young on the other, which it's come together, has come together to put this conference. I also want to say that as we think about the aspect of the role of regulators, it also needs to be mentioned that all regulations have inherent costs in it. And I think it's important for us to recognize that how do you balance the cost of regulation on the one hand and the need for regulating on the other. And the principles of that regulatory framework needs to be rooted in some of the more fundamental values of transparency, of clarity, of ethics, of in a way, most of the time when we talk about regulation, we don't understand and appreciate how it has the potential to create new forms of barriers and even undermine innovation and opportunities for us to seek some of these technological and digital transformations. None of these questions are simple, nor the answers going to be easy. But that's when thought leaders like all of you, institutions like the ones that have come together, have a very big role to play. I think it's important for those who are both in the government, appreciating the views and perspectives of those who are outside the government, and those who are outside the government to understand and appreciate the predicament and dilemmas that those who are within the government end up facing when they are addressing issues. That OP Jindal Global University is well suited to host this panel discussion, and I hope that the proceedings of today's discussion and other deliberations will inform the public policy thinking that is emerging in India and other parts of the world as well. With those words, I would like to once again congratulate JIRICO and ENY for putting this together. Thank you.
Thank you, Raj. I now invite the two moderators of the discussion, Aviru Bose and Sangeeta Singh, to kick off the panel discussion on the topic India's digital reset, role of regulators in times of COVID. Over to you, Aviru and Sangeeta.
Thank you, Ashish, and thank you, Raj. I wanted to add on to my Vice Chancellor's and Ashish's remarks, welcoming all the panel speakers. I have had the distinct pleasure of working with many of them. So they have been my former bosses. Some of them have been my former bosses. So it is kind of really nice to at least virtually meet all of you. I think both Sangeeta and I will be just making very short remarks in terms of just the background thought about why we did this, why this concept note, and then we will start the conversation, which I think is more important than our initial remarks. I think there has been, as the US press has been reporting, and we have our very distinguished Professor Daniel Sokol joining us from the United States, as there has been a report of what they have termed as a bipartisan kind of collaboration between the two parties in terms of regulating big tech. And there has been no official statements yet from the incoming Biden administration, but there has been, of course, various efforts in terms of how best to regulate big tech. And there has been similar movements across jurisdictions. I think Ashish mentioned developments in China. Europe has been quite aggressive with big tech for quite some time. And even 2 to 3 weeks back, the chairperson of CCI has actually given an interview where he expressed the desire that why one size fits all mechanism will not work for regulating digital platforms, and a much more nuanced approach needs to be advocated for regulating big tech, including digital platforms or e-commerce markets. So there has been, even before the COVID pandemic had hit us, there has been developments within India in terms of how best to regulate technology platforms, two of which has been mentioned in the concept note itself, which is both the market study as well as the review committee, the competition law review committee's focus on digital markets. But there has been other enforcement developments also. There has been decisions where, what against WhatsApp, Uber, Ola, all of them have huge ramifications in terms of what would be the future of regulation of digital markets, generally speaking, in India. So with that has been the background. So I think the focus on COVID is only it comes by reference. There has already been there has been an effort from CCI as well as from the Indian government to better understand how technology should be regulated in this country. Of course, looming behind all of this is that larger question of how to regulate data. which again forms a central sort of driver for all of this conversation, given that the post-pandemic reforms, if you say, or economic recovery will be based upon platforms or will be based upon technological markets where data would be of quite a significant issue in terms of how that will be regulated, both personal data as well as commercial data. So with that, I'll just ask Sangeeta to maybe speak a few words, and then we will just start with our dialogue.
Sorry, sir. Thanks for inviting me. So I was going through CLRC's report by CCI, and I noticed that, there is a huge mention of how digital companies should be treated, so much so that the traditional threshold limits for approving any merger or acquisition will also there is a recommendation that can be changed so that more and more digital companies can fall within the ambit of CCI's approvals, either from CCI's point of view that there is no anti-competitive tendencies that take place because these digital companies get complacent, or from the digital company's point of view itself that they do not, they understand their limits and they do not cross it. And that's a big development, I would say. And with this, I think we can start with the questions.
So if we could ask the first question I'd want to ask to Dr. Geeta Gauri and Payal Malik is that do you think that there should be a renewed focus of understanding what constitutes consumer harm within the existing Indian competition law framework? Again, referring to digital markets coming out of this COVID crisis, or should we rely upon the old school traditional methods of assessment of consumer harm? Has anything changed according to your experience of handling these issues during the crisis?
Do you want me to go first, or shall I ask Payal to set the ball rolling? Maybe old age, I can take one first.
Either of you, ma'am.
Let me start off with Payal, because she's very much into all the cases and would have a better understanding of the current thing. I think you posed the question extremely well, because what has been bothering me is what I call is the Google first case and the Google second case. And the Google second case, we have two former interns or someone coming in and setting up the case. I forget the name. And in this whole thing that I have been trying to look at it, and we talk about consumer harm, is there something known as homogeneity of a consumer? And also what bothers me in this question of a homogeneity of a consumer, the Commission does and did have a tendency to lean towards the European approach towards the cases. The European consumer and how they would look at harm. But while that might be nice because both EU and the DOJ are mature commissions, but in India, we have to be able to define who's the consumer. And this was a very big issue because the Indian consumer is extremely quirky. I've been writing continuously after I've left the Competition Commission on these issues, especially for the Competition Policy International, on how do you define consumer. And the consumer, the way it's defined in the Act will have to be uniform. You look at 2S, R, and T, they would have to have a uniformity in the concept of the consumer. But when you're looking at cases, you need to understand which consumer. And I think that the insight, which was not stated, but I got really, is from the dissident order of the Google first case. Because in the Google first case, where they've been saying that Make My Trip did not make so much of a profit as would be expected from the ranking of Google, the interesting thing to note is the Indian consumer, and I'm one of them who's always on the net, I go down fully to the bottommost to find the cheapest price. Cost is very important. And this becomes more important in the concept that the digital India is not in terms of the question of looking at Google or the search engine, but in terms of apps. And the digital mobile ecosystem is so dynamic that one can always get apps wherever you for what you want. And further down with the COVID, what I have realized is you have websites. These are not platform markets. They're not riding piggyback on Amazon or any one of them. Neither are they apps which are there on the phone. These are websites. And when I have to buy a sari now, I just Google my usual customer or my usual seller in Bangalore, and she sends it across to me and her website. So there is a complete dynamic change. And when I looked at the act, and I keep thinking, should the act have been modified? But I don't know how that can be done. Instead, what we require is some science or some kind of a guidance note, because we have to develop some amount of general principles of how you are going to look at platform markets and how you're going to look at apps and how you're going to look at websites. And if these guidance notes, I will take it up later. I am quite happy with the nuanced approach the Commission has maintained, but also very disturbed in a paragraph that they have talked in terms of saying that if you have signed the MARA, I think this is similar to what Google gives for an agreement, then you're going in for contracts which are unfair. And let me stop here because I have a lot to say even on contracts which are unfair, because it's a business model. And when do you decide when a contract is unfair? And I leave it to Payal to take over, and I'll get back into the argument later so that we can have different viewpoints on this aspect.
Ma'am, you'll have to unmute yourself.
Payal?
Yeah, so the standard line is unmute yourself. Okay, so I got into that trap too. Thank you, Aviru. Thanks to JIRICO, and this is important. Means as much you debate, the little it is. As this is more of debate, the better it is. I think Dr. Gauri knows the cases much better than I do for some reason, because we deal with so many issues that we lose track. But having said that, yes, this is a time where dependency, and so COVID does impact how various companies are dependent on the digital economy. And so therefore the relevance of this discussion therefore increases. So because we do understand that the ubiquitous role which technology plays in our lives has even more accentuated due to the pandemic-induced lockdown in many countries across the world. So this may have an impact on entrenching the power of many technology firms. So that, I don't think so disputable. No one here disputes that these gatekeepers in the various verticals of the digital economy have a status such that if you have to access any product or service, you have to go through these certain gatekeepers. So what competition law is bothered about is about, by and large, by these gatekeepers. Having said that, there are certain behaviors of the firms which are also, in the sense, cut across firms. So it need not necessarily be dominant firms whose behaviors are problematic. It may be smaller firms also whose behaviors, or smaller platforms whose behaviors may be problematic. However, the digital economy, because of these online platforms, are distinct from other firms. So this platform configuration itself is very, very important in our discussion, because who is the consumer? Because you talk about consumer harm. And I think the debate is missing the point when it just looks at, because given that there is such a robust economic framework, the debate is if it misses out on the two sides of the platform and just focuses itself on the end consumer. And the end consumer for a single generation, and not impact on the end consumer across generations. And when I'm saying across generations, I don't mean across biological generations. I mean across time periods, because in dynamic markets, these time periods could be as short as 5 years to 6 years. So, so consumers, as I said, is the end consumer. So the consumer harm, qua, I'm starting using a lot of legal language. So qua the end consumer, and consumer harm to the, because these platforms are intermediaries, in some sense, the supply side of the market, and that is the small and the medium enterprises. No flavor of protectionism here, please. So the small enterprises who are dependent on these platforms or on these intermediaries to get access to the end consumer. So in that sense, they are also consumers. You may call them customers, you may call them consumers. The Competition Act clearly defines intermediate consumers as consumers also. So if we look at the supply side, and Sangeeta is here, and she was the implementing partner for the e-commerce market study. The supply side is highly fragmented. The supply side includes these consumers or quote unquote customers who are increasingly dependent on these platforms, and they do not have what is known as an unequal bargaining power. In such a situation, even for the consumer now at the other side of the market, you require more and more players to be interacting with these consumers, the final consumers. So the firms that play an intermediation role between various enterprises, these firms have access to large and unique data sets. They are able to move into adjacent markets either through acquisitions or by having access to sensitive business data of other market players on their platforms. These characteristics of such online platforms have corresponding concerns for SMEs. So we'll just briefly come out with what we thought the SMEs or the small vendors face. And let us also not forget, we are talking about India. We are not talking about US. We are not talking about Europe. We are talking about India. Again, taking you back to the preamble of the Competition Act, which is an act keeping in view the economic development of the country. So within the contours of the act, if there is a consensus, even a consensus amongst all of us here, that the vendors and the customers on these platforms are intermediate consumers as defined by the act. So what do they have to face? They face arbitrary delisting. They are faced with one-sided amendments to terms and conditions. They have to contend with the data masking, which prevents them from accessing critical customer data of their own customers. They find themselves competing with the platform on which they are listed, and there is non-transparency in the search functionality on such platforms. And search is the key. Search is the king. Search is the key. Search algorithm is provided by these platforms. If you are blessed by these algorithms and you get an unbiased search ranking, you do well on a particular platform. If you do not, you are doomed. So with these words, I think my just brief point is, please let us have some understanding of who the consumer is.
Thank you, Payal. Danny, if I could just ask you to chip in for a minute, like sitting in Florida and going through what the US has gone through in terms of this crisis, and the fact that you know the Indian regime so well, do you have any sort of recommendations, sort of from your vantage point of knowing and dealing with these issues in the United States? Do you have any recommendations as to how India should kind of progress from the antitrust regulatory point of view?
First of all, thank you to the organizers and thank you to my fellow panelists. When you say the situation in the United States, we're going through both health pandemic and one can say political pandemic at roughly the same time. There is a move distinct from competition law to think about regulation, about what kind of power should private platforms of all sorts have. And it's a very legitimate debate as to how much self-regulation versus how much government regulation. I'll give you a few guiding principles. In the United States, we're much earlier in thinking about this. We had been really focused exclusively on competition law. Everywhere else in the world, there seems to be a mix of both competition law and regulation. Sometimes the regulation seems competition-like. Sometimes competition law seems less competition-like and more like regulation. How might we think about it? I'll give you 4 basic points. Number 1, focus on why, not what. So is a platform itself in a core service creating some kind of structural impediment to competition in and by itself? And that is to say, any kind of focus should be on, in my mind, specific anti-competitive practices, creating structural barriers to competition rather than simply, is this a platform? The reality, both in the United States and actually in India, is we had some first movers. These are what we think of typically as big tech, and depending on how we define big tech, it's 4 companies, it's 5 companies, it's 7 companies. But increasingly, traditional companies have basically moved into digital transformation, and we're seeing the same kind of issues emerge in traditional industries. I'll give you just a few examples to set the framework for a broader conversation. So think, for example, about banks and insurance companies that are transforming into online platform intermediaries of fintech services in response to competitive pressures coming from digital companies. Car manufacturers are building ecosystems of mobility services. In healthcare, we have digital platforms to optimize the quality and accessibility of care services. I think that matters a lot more now in a time of COVID. But I think across all of these types of platforms, we have to focus on specific type of behavior, because when we regulate in a way that is coarse and doesn't take into account specific market dynamics, we tend to regulate in ways that actually diminish innovation and competition rather than the opposite. And the clearest example to me of that is GDPR in Europe, which on the one hand legitimately said we'd like to have higher privacy levels, but had unintended consequences. It actually led to an increase in relative concentration in the web technology vendor market. Websites were less likely to share personal data with small web technology providers, so this gets to Payal's point of SMEs. And GDPR has negatively impacted growth of AI startups with customers in Europe and reduced investments in European tech startups more generally. So when we go to a more regulatory solution, we need to have, as with medicine, more precision to make sure that we're not creating more harm than the good we're creating, especially when we're trading off a series of values.
So before we move on to the next question, I have one question to Payal. On the onset of pandemic, in April, CCI came out with an advisory appealing for cooperation amongst the vendors, especially in the healthcare sectors, the small and medium enterprises that you were talking about. Did you hear of cases where consumers were put to harm because of any kind of collusion or any kind of dominance to take advantage of the pandemic?
Not specifically in the healthcare sector, but as you must be aware, so now we are moving outside digital markets. But as you may be aware, there has been some talk about steel companies and cement companies trying and colluding. Means these are, I'm just speaking from the newspaper reports, which you also are aware of. So whether or not, in order to, in the revival of the economy, when there was an upswing, whether or not then they are colluding together to impact prices. So that issue is there, may come before the commission, may come as a suo motu case, or may come as an information. Second is, of course, the cement companies. So cement companies also, again, revival, construction activity began, etc. So in a way to make up for all the losses of the lockdown period. So is there a meeting of the minds vis-a-vis the prices in order to increase profits, etc. So those cases are there. But pandemic, in fact, if I come back to the digital market, and that's why we have been working very, very hard, even during the lockdown. What happened was there were a lot of deals taking place in the digital markets, a lot of mergers and acquisitions. Mergers and acquisitions, in fact, because the digital markets became so important and so indispensable, And so this was, so according to some data which I will speak of, there was this Deal Logic. Deal Logic came out, said that it said that in the early part of 2020, the value of the deals that have taken place in the technology space in the first quarter have far outpaced the investments made in other sectors. So from a pandemic perspective, if there is any connection, I think the connection more is in the mergers and acquisition space, in the telecom space, in the technology space, than in the conduct space.
Okay. Next question is addressed to Manas and Ashutosh. Is competitor cooperation the new normal in the aftermath of COVID-19? What would be an appropriate regulatory framework to assess inter-competitor cooperation? And in the past, we observed that there were a few cases where CCI issued cease and desist. It made an appeal of cease and desist rather than imposing penalties, especially on some companies related to industrial bearing and the railways. So, do you think this was because of pandemic? It was an accommodative stance that CCI took, or do you think this is kind of a softening policy towards industry? First, Manas, and then Ashutosh, please.
Okay, thank you very much, Sangeeta. And I also echo the sentiments of my fellow speakers that we are very, very fortunate to be invited for this wonderful event. And I thank JIRICO and ENY for this opportunity. So the question which Sangeeta you have put across, so logically, it is possible that people may like to cooperate and coordinate because that is the way forward when the demand slides to an extent where the supplies are not having there and the demands are also skewing as the situation becomes lopsided in the market in terms of market economy. So the possibility of the businesses who are not here for doing charity, they would definitely like to find some way out. So the cooperation and coordination logically, even in the non-COVID time, is quite possible, and why not in COVID time? So my answer to that is, without having any data about that, that there is a logical possibility that the business houses would like to cooperate to find where their coordinated activities can meet the demand, and they can rely upon the 19th April 2020 CCI advisory that if they can really reach out to the healthcare sector or to the essential services and meet the demand there and justify to the CCI with their robust justification as to why they cooperated, I think that's quite possible, quite logical, and that may perhaps not fall foul of the Competition Act because they can justify. What the whole issue is that whether you can really justify why you have coordinated. As regards your questions relating to the two orders, that is the 5th June order of 2020 and 10th July order of 2020, the first one relating to bearing industry, the auto bearing industry, and the second one relating to composite brake blocks in the railways. So you are right in saying that yes, there can be a leniency approach taken by the CCI, which to my mind was very noble and innovative, because end of the day, the cease and desist order is as draconian as imposing penalty. Because a cease and desist order means the Competition Commission has found the opposite parties to have breached the competition law relatable to cartel. If I go back to the MRTP days, that was the only penalty to be imposed against any defaulting respondent. So to my mind, the cease and desist order is as strong as imposing a penalty because it is an appealable order. People can prefer an appeal against that order because you are now a registered defaulter of Competition Act before a competition authority. In that regard, cease and desist order is definitely showing that the CCI is not lenient in giving or handing out a penalty, but at the same time, of course, no financial penalty, but at the same time, they understood that industry should not be burdened with more and more pecuniary penalties, and that way they have balanced between the merit as well as the economic downturn. If that is fine, then I think Ashutosh may like to continue.
Yes, Ashutosh, please.
Yeah, thank you, Sangeeta. No, I completely agree with what Manas sir has said. That until the time you have a justification for the corporation, there is a chance that you may not fall foul of any the provision of the Competition Act. In fact, in its April order, the CCI itself has kind of laid down a test that the cooperation should be to the extent that it's important in order to provide essential facilities during the time of pandemic and lockdown. So that test can be used as a yardstick to judge whether a cooperation was with the intent to actually facilitate the supply of essential facility, or it was with some kind of an anti-competitive motive. As far as the not imposition of penalty in few of the orders by the CCI last year, I will say that that was quite a pragmatic approach by the CCI, considering the kind of economic situation we were in at that time. So CCI, in its discussion, felt that imposing a penalty might, in fact, lead to kind of the entire closure of the business itself. So they in fact went for only cease and desist order. And as Manas has said, that even the cease and desist order have its own impact and consequences. Certainly, it leads to a reputational harm for the companies who have been found guilty of a competition law provisions, which may impact in future cases against them.
Again, just to kind of sum up what both of you said, can we now, going ahead as we come out of this pandemic, can we say that the efficiency justification which was available for joint ventures under Section 3, that shadow of that kind has been extended even to naked restraints under Section 3.3. Can we go that far, or is it just as one or two examples which came during the crisis?
Avirup, what I would say is that the joint venture, which continues to be part of that safe harbor under the Competition Act, and in fact, until now, most of the joint ventures have been considered more of a merger control rather than an anti-competitive conduct. So insofar as what you are trying to suggest that whether there is an overlap, I don't agree with that, because legally, CCI has not really caused any exemption to the Competition Act. Because once they have found that there is evidence of capitalization amongst the OPs, they handed out a penalty which is available under the law. They have not completely exonerated even without a cease and desist order. So in a case of a joint venture, which is falling foul of Section 3, not getting the benefit of exemption, then obviously there would be evidence that the joint venture is a sham, and the evidence is indicating that the pernicious provisions of the Section 3.3, that is price fixing, allocating customers, limiting production, and bid rigging, are otherwise found, which has no justification on economics. So in that regard, I think joint venture, which is having the exemption under the competition law, is typically, to my mind, is a efficiency enhancing joint venture or a merger control. It just cannot be compared with the advisory which the CCI has come out in April of 2020 and has given some leniency with regard to penalty. I don't think there is any overlap, and the CCI is very clear in its order.
Thank you, Manas. I want to just kind of combine the next two questions. We are running a little short of time. Next focus, of course, when we have discussed Section 3, we have discussed cartelization. So naturally, the focus goes to our favorite section, which is Section 4, in terms of where all the confusion lies. How best to regulate the behavior of dominant companies. And I just want to just kind of begin with two very initial thoughts, and then I will open it up to the speakers. The thought being that, there has been, given the tradition of what is considered as, exploitative abuses within Section 4, as consumer exploitation. I think there was a question that even Sangeeta wanted to point out. Does consumer exploitation within the pandemic something that brings us under Section 4, or just the larger question, as Payal suggested, and we have an entire question dedicated to that. There has been a series of investments in tech particular companies, and there has been actually newspaper reports which says that India will be coming out of this pandemic with monopoly players more than India would have perhaps thought so. So given this factor in mind, is there something that the CCI should do to regulate the behavior of dominant tech companies, big tech or otherwise?
So
we can begin. I mean, I can ask sort of Payal to begin, and then I think Manas and Danny, you can chip in.
So I think, as Danny has basically said, just until unless you see it's a structural problem, and competition authorities are not, at least in India, we are not moving towards that direction where we say there's a per se structural problem. This per se structural problem issue was brought out in fact by Leena Khan. So at least that is not the issue in India. So if there is no per se structural issue, then why bring in regulations from the competition law route? Second, regulations are known to be blunt. They cannot sculpt solutions based on the issue at hand. And so therefore, I think central to this would be antitrust law and a case-by-case approach. Yes, it has its own limitations. It's slow. It's process-driven. It takes times in the courts, etc., etc. But it does bring in through jurisprudence some sort of regulations that what is acceptable and what is not acceptable. Having said that, there are various arms of the government who are looking at certain platforms and certain digital markets and may bring in certain regulations which may have an impact not only on these large firms but also on the small firms to regulate their conduct and their behavior. But to get these code of conduct things within the ambit of the competition law, I think would be defeating the purpose of antitrust law.
Manas, do you want to add anything from your practical point of view of advising your clients?
I agree fully with Payal because our Competition Act is all encompassing. I personally feel that there should not be any tweaking required by way of some kind of a change because the law has been drafted in such a manner that it can really encompass every unforeseen situation which it needs to rectify. Because the definition of enterprise, if I go clause by clause in the act and then the other supporting provisions and the decisional practice which has emerged and now getting more or less confirmed from the Supreme Court, we think we are getting a robust jurisprudence to handle these situations. And I know for at least 39 Supreme Court judgments which say that we may rely upon certain persuasive value from common law jurisdictions if we do not have express legislation. We have express legislation. Why should we really fall back upon all the time on the persuasive value of the West? So that is one. Number two, the decisional practice of the Supreme Court will also give us a way forward to see as to how the highest court views these decisions of the lower courts like the CCI and the tribunal. Of course, I should not be saying CCI as a court, but at the same time, it's ultimately the appellate authority would be seeing what the inferior adjudicatory process had given them to look at it. So in that context, yes, I am saying that it is a court. But my whole idea is that I personally have always been the advocate to my clients that the law is so comprehensive. You can provide safe harbor by your conduct, by your evidence, by your documentary justification. But if you do not have justification, this law is not going to be interpreted prospectively for antitrust issues. Antitrust issues will have to be justified retrospectively. And that, I think, is the key to answer your question, that if you have got an antitrust conduct in the past, which has fallen foul of any of the provisions of the Act, be it a digital market or an abuse of dominance, though I agree fully with Payal that it is a rule of reason law, but at the same time, the rule of reason has to be proved. It simply cannot be said that it is a rule of reason law. You have to prove that why you believe that you have got a justification for every kind of antitrust breach, whether it is exploitative practice or an exclusionary practice.
Actually, just to continue with, even in exploitative practices considered to be per se, there could be an objective justification, and ONGC case is one of those where the behavior which appeared to be exploitative on part of ONGC, there was a reason why they indulged in that activity and was therefore objective justification was allowed for.
And to add to that, on 19th of January, that is day before, 19th January, the CCI had come out with a very interesting order that Haryana state government was having certain policy level issues, which was having a commercial ramifications in the market. They were having some kind of a distinct feature with regard to the private builders vis-a-vis the government builders. And the private builders had brought a matter before the CCI alleging that the HUDA, that is the Haryana Urban Development Authority, was indulging in abuse of dominance. CCI concluded otherwise. Because, it has to be a justification which, in spite of the fact HUDA is not only a dominant but is a monopolist, CCI found justification and exonerated HUDA from the allegations. So that I think sums up that it has to be on case-to-case basis.
Danny, again, big tech, I know, is the flavor of the season in America too. So do you think that now that there has been, there is a new administration, do you think that Leela Khan's proposals or, the draft proposals of Senator Klobuchar in terms of regulating big tech, will that become a reality, or do you think that those are extreme measures in terms of regulating big tech?
It's too early to tell. We don't know who's going to be in the agencies. We also don't know. I'm sure that there will be some legislation of some sort. What I will say is what we saw from the House Judiciary Report, particularly the last few pages that had nothing to do with big tech, but was just a laundry list of other issues. If you're going to have legislation in the United States, which is a common law system, the reality is it's the courts in the United States that have shaped competition law more than any legislation. And what we know from other areas of law is that legislative overrides have been ineffective. And then, so what does that leave us with? It leaves us with who's on the court. That's a gradual process. But also, if we believe and we take the Supreme Court at their word in the United States that competition law has a common law-like development and that stare decisis doesn't apply. Why? Because economic learning allows for gradual change of competition principles. If we take that at its word, we will see a recognition of certain nuances that maybe we didn't understand before. But the one experience that we have, the closest thing that we have to some kind of a superior bargaining type legislation, the Robinson-Patman Act, over the course of its lifetime, the court basically interpreted it to be exactly the opposite of what it said, expressly the opposite of what it said. So I think many of these legislative attempts are a bit misguided because it doesn't understand that they're focusing on the wrong institution.
So, I know, Anuj, just before, we go on to the next question, like being in a room, although virtual, with lawyers, it might be a little suffocating for you. But, I was just wondering, when you teach technology, I know you teach, you take electives on artificial intelligence and you take classes on technology platforms. From the point of view of someone from your vantage point, any advice to what we are all discussing? Do business models even think about these issues when they are developing themselves, specifically reacting to an economic crisis as sort of devastating as COVID?
Am I supposed to answer?
Yeah. Geeta ma'am, I think Anuj, and then if you...
I'm not too sure who's supposed to answer.
So Anuj, and then if you want to add, Geeta ma'am, you can just add your views. I was asking the question to Anuj, but you can also join in.
Anuj answer. I'm in no hurry to get into any discussion.
Okay. Yeah, so first of all, thank you for the organizers. It's lovely to be here. And I was really engrossed in all the conversations that were going on, especially from the lawyers. So the way I approach this, it's mostly from the economic economics perspective. And the way we approach this problem is, I usually say that, so an economics perspective of whether the notion of a data opoly makes sense, like using in-depth analysis of whether large data sets of digital data are related to the typical sources of market power, right? So we see, like, the way we approach in the business classrooms is whether the large amounts of digital data that are typically observed on large technology platforms, the big tech, typically give rise to the structural conditions that would lead to antitrust concerns, right? So more or less, I address three sources of market power that are recognized broadly by economists: network effects, and switching costs, and essential facility. So I look at these things from that perspective of under this framework, and then build on how algorithmic collusions and the advent of big data impacts antitrust and the regulatory frameworks. So that's essentially, does that capture what you are trying to ask me?
Let me just add, because Anuj, I think you put it very, very clearly. And there is a certain kind of obsession that is going on in terms of data and the big data. And the emphasis that really that I'm trying to say when I say that in India, our whole technological development is on the mobile ecosystem, is to show who is able to get the felt need. You know, having done a lot of data work and data analysis, a lot of data is white noise. And to be able to catch the opportunity of where the felt need is, that's the person who succeeds. And if there are a number of people competing and some fail and some succeed, it should not matter. And this is a point of the general principles which even Daniel was raising, that the logic of the market cannot be taken up by the regulator, who also wants to play God and intervene. You see, so your points that you have said on the three things on network effects, switching costs, and essential facilities is only to try and see if there is any kind of impediment for others coming in, and is it required for the commission to intervene, or should the market just allow itself to readjust, because you won't go into business unless you've sensed a felt need. So it's very interesting, because I keep thinking of data also. And is data such an issue that others are not able to get in? And I think we need to think a lot about it.
So our next question is an extension.
In fact, if I can ask a counter question to Anuj, so do you think data is such an unsurmountable barrier to entry? With the fact that you are dealing with data sets, and you know the kind of data sets which these companies have, and do you think it's unsurmountable or it is replicable? I think that's a simple answer.
And to put it simply, I would say it depends on the context. And I will here, rather than just saying something theoretically, I have some quantitative evidence as well, right? And if I can just put it in a minute or so. So there was some research here where they examined, for example, the search engine accuracy, when the search engines changed the length of time that they retain data as a response to a crackdown by the European Commission. Now, researchers found here that there was no effect on search engine accuracy as measured by whether a consumer felt the need to repeat the search. Now, there is a potential explanation. The search engines operate a long tail business where many search queries are unique, right? As a result, more data on what consumers did in the past is not useful. So instead, what is useful is a smart predictive algorithms that help predict what a user might mean or want by their search. This is another form of learning by doing. Then there are numerous examples like that where the future, so even to my students, I provide them a HBR article which says that the future is about less data and not more. And it's more about algorithms which can predict what a customer wants and how they are thinking in a sequential way. Of course, keeping in mind that algorithms can collude, and also there is inherent bias in their predictions.
Anuj, I ask that one question, because what bothers me on the algorithms, while the algorithms, the way they have been earlier programmed and they're doing searching, the searching does result in a lot of collusion.
Yes,
you see, and then what should the commission do? That's a very major issue that comes up, because we had a case right in the beginning which dealt with the air tickets.
Yes,
And
please.
you want air tickets at a time when there is a Diwali season, you find that all the pockets are gone of discounts.
Yes,
So
please.
the algorithmic collision is a big thing, and that has to be thought of and worked out. And I think this is something Daniel would know more about it, because it has bothered the DOJ a lot. I don't know now with all these elections and all that on. I don't know what is bothering the US. But you're right. It's one thing leads to another.
And just to add here thank you, these were awesome points. But Danny shared, that book is something that I recommend to my students. There is another book, since I'm teaching these days, there's another book I recommend, which is Prediction Machines, which is Economics of AI. And then there is third book by Aaron Roth, which is The Ethical Algorithm. And the fun part is we have an engineer, a computer science engineer, who will be coming to our students and talking to, there you go. So Aaron Roth is going to be in our classroom on 18th of February, talking to my students in the classroom. So
What's the first book?
Sorry?
The first book.
So this is Prediction Machine.
Matters, Ethical Logarithms.
Yes, please. Yeah.
And you said 3 books.
And the one is which
Anuj didn't mention is the only book that matters is Prediction Matters. Why? Because that's the only one that has a Daisy co-author.
Yes, absolutely.
Okay, taking the discussion on data further, how do you think CCI should approach the issue of data governance and data security? We all know a personal data governance bill is pending with the Standing Committee of Parliament, and there is a non-personal data governance framework which is being worked upon. I'm sure lots and lots of issues, antitrust issues, will come to CCI also. But would CCI be the appropriate forum for it, or will there be, a tendency of forum shopping, because there would be this regulatory framework and there will be a regulator for that also, and there would be various ministries. So how will CCI handle this? The question is to Payal, and Anuj can also answer that, and then anybody else who's interested.
I think now they are pretty standard. I'm unmuted. Yeah, now they're pretty standard frameworks to analyze big data and the economic power which big data rests with these companies. And in fact, I am with Manas when Manas says that a modern law such as the Competition Act can take in under its fold so many new aspects that when I was the convener of this working group on new age markets and big data, we did not find the need for amending the act in order to account for the power which big data accords to certain companies. But having said that, it doesn't mean that we should jump into every aspect of data and data protection. I am a sincere believer of, and these are my personal views here, of a regulatory architecture which governs the same aspects from different lenses, but may give the outcome which even the competition law would be happy with. So whether the data protection law, which is the personal data protection law, when it comes to India and when it is implemented, now there is a discussion. Of course, everything needs to be thought through. All the infirmities have to be discussed. You don't want a GDPR kind of a situation. What Danny has been mentioning is, in fact, you don't want a regulation or a regulatory architecture which is very good for big companies. In fact, I have seen and I've heard Facebook loves regulations. Facebook loves regulations because large companies, in fact, can be compliant of the regulations because they have a huge regulatory compliance team. In fact, it may impact entry of smaller firms who are not able to meet those kind of regulations. So what I feel is, yes, you do need some kind of multiple instrumentalities when it comes to addressing, be it competition issues, be it market power issues. Competition Commission is fully empowered, and the competition law can take various issues of big data stemming from market power. So it is not limited given the legislation which we have. But yes, if there needs to be a position and there needs to be a law for data protection, which may give power back to the consumers. And if it gives power back to the consumers, in some sense, it democratizes the data and it decentralizes the data.
Anuj, do you envisage a lot of competition cases when this data protection framework is in place? And Ashutosh, you may like to chip in.
Go ahead, Anuj.
Maybe Ashutosh can go ahead, and maybe then I can build on Payal's mention. Yeah.
I agree with what Payal said, that we should not be eager, happy to jump to regulate all these data related issues, because seriously it's a very complex issue, as it entail interplay between different fields of law, different rights and interests. For instance, the sharing or collection of data may interact with the privacy right issues of data subjects, as well as the proprietary right of the companies who collect and process those data. And at the same time, it may require for the competition authorities to cooperate with other sectoral regulators, as it has been proposed in the data protection bill, that there will be a data protection authority which will regulate the data privacy related issues. That bill also suggests or provide a provision in form of Section 56, which states that if this data protection authority feels that there is any case in which their decision might impact the provision of any other law, they can cooperate with that other sectoral authority, and even in fact we can enter into some kind of a memorandum of understanding. So that's why I feel now that the CCI should, for the time being, they should adopt a wait and watch approach in how to regulate or to govern the data related issue in this country. And in fact, on top of this, last year I believe NITI has also come up with a report where they recommended for formation of a regulatory authority for governance or regulation of non-personal. And in that report, they recommended that regulatory authority or the proposed regulatory authority will be much more equipped than Competition Commission of India to deal with any competition law related concerns as far as the non-personal data is concerned. In my personal opinion, that kind of a recommendation may lead to too much regulation, and as Dr. Gauri and everyone in the panel have pointed out, that there is too much regulation might lead to some kind of uncertainty for the industry player, and it has its own cost. And as Dr. Malik has also pointed out, that too much regulation, in fact, can sometimes act as a barrier for the new entrant. An established player might be very comfortable in complying with all those regulations, but a new entrant might be some kind of entry barrier for them. So these are my thoughts on this data governance.
Anuj, could you be very? I think we have overshot our time. These discussions are so interesting. Could you be a little brief? And then we can just quickly move on to the next one. Thank you.
Yes, please. What I can say here is that so if we can take a step back, right? I mean, so when we are talking about regulations in any form, so for businesses or for firms, and I'm coming from a business school perspective, there are three sources of market power that I just mentioned, right? So here the assumption is that these sources always favor the big players, right? But there are enough examples to show that's not the case, right? And since we are short of time, otherwise I had some specific cases that I can bring, but I just want to say that there are many reasons that to be optimistic, that rather than reinforcing network effects and switching costs, there are many instances where the process of digitization has actually weakened them, right? When it was the case of the hardware, and now we are moving to software, the impact of network effects actually has weakened rather than becoming strong, right? So Microsoft, gone are the days of the Microsoft. Similarly, just to give you an example of GDPR, I can just put that here, that there has been research on the potential anti-competitive effects of privacy regulation in general, in terms of like suppressing competition in online advertising markets, right? The basic idea is that the more strenuous are opt-in requirements, the more likely it is that consumers will opt into sharing their data with just a few firms, right? Rather than being willing to share the data with new firms or potential entrants. So there is a possibility that regulations like GDPR can actually unintentionally suppress the ability of new startups to rival existing large technology firms. So here, the regulations not only will they are not going to deter the big players, but only they can be a deterrent to even the small startups with just these things like opt-ins as well. So I know we are short of time, so I won't take any.
So actually, there is a question that has been raised. I mean, I think Daniel, you have written on this, so maybe I'll ask that question of you. The question is being asked by Dr. Indranath Gupta, who is the convener of JIRICO. That we are talking about regulating data, but what about licensing of data? Do you think that we have to develop something similar to FRAND terms when these licensing of data is concerned, or do you think that is a conversation that we should leave for another conference of ours?
So in many ways, we could, instead of licensing, we might think of those moments when we might want to encourage data portability. In lieu of some kind of licensing regime. Not sure about how FRAND would work in the data context. It's an interesting question. I think these issues are going to actually collide with regards to 5G and automobiles shortly. But it's not something I've given sufficient thought to.
Viru, I can add on the licensing aspect of data.
Sure, Ashutosh.
As I mentioned, that there's sometimes these data can also be claimed as a proprietary right of companies. They can claim copyright over that. And in fact, in Indian copyright statute, there is a compulsory licensing provision. On the aspect of FRAND related adoption of FRAND principle in the context of data licensing, in fact, the MATI has recommended that for the processed non-personal data, FRAND principle can be applied. Surely the authority who are equipped or conferred jurisdiction to grant compulsory license for copyrighted work, they can adopt that principle or the jurisprudence of FRAND and can deal with the data licensing issues.
I think, Aviroop, this is the topic that should be taken up. For the simple reason we've had cases dealing with Ericsson, we've had it with Intel, we've had it with Qualcomm. The High Court has taken a decision, but the Commission has not. How do you look at licensing? How do you look at pricing of standard essential patents? And what is the approach of the Competition Commission? And it's important. Today's discussion is very short. You've gone into data. But when you look at anything, I think it's very, very important that one identifies which market you are in. Are you in a product market? Are you in a platform market? Are you in a data market? Or are you in the market for standard essential patents? Because the economics of each of them differ. And I think, Anuj, you will understand, because the cases that you have mentioned, I have looked at them. And I know how it means to be restricted if you want your Competition Act just within the traditional product market. So since the discussion is now coming to an end, and I look forward to reading what Daniel has suggested and what Anuj has also suggested, we have to open our minds up. And we have to open our minds up to different things. And let's wait for what the Commission says on FRAND and on these cases which I have suggested. So you can have a separate discussion. You'll excuse me if I leave because I have to go somewhere. Okay? Right.
Sure. Okay, just moving on to the last question. How do we balance interests of consumer, domestic and foreign firms and future of India's digital economy? Most policies have recognized the inevitability of digital sector. How should policies be framed so that digitization doesn't become a necessary evil, but a necessary good?
So if we could just restrict ourselves to last closing comments on this, like basically what, how do you look at the competition and industrial policy? Very brief points. Manas, you can begin, and then we can sort of, so Payal can also sort of chip in. I think we have really shot over in time. Manas and Payal, very brief points. How do you sum up? How do we look ahead for?
So if I go first, Aviroop, the policy, as a lawyer, I would always go by what the judicial processes are. policies are generally not being considered by even the Supreme Court and High Courts to be looked into in the event of a someone is coming before them as a party aggrieved, because policy is beyond the domain of the courts, and so is it is beyond the domain of the CCI. However, with regard to the industrial policy, if you are asking specifically in this seminar, it is talking about whether the foreign direct investment will have any impact on this current situation. To my mind, CCI has, even before COVID, now and ever beyond COVID, they are very much into enhancing the foreign direct investment concept through their lens of Section 5 and 6, that is merger control and joint ventures. Because if you look about the 780 odd merger control which have so far been approved by the CCI, there were many which were cross-border filing, and where the consideration amount could be definitely be correlated with foreign direct investment, because end of the day, once the combination has been allowed, it has enhanced the economic efficiency in that particular sector. And since this has been the strategy of the government, which has in sync with the Competition Act and the decisional practice of the CCI, I personally would consider that the foreign direct investment, insofar as industrial policy related issues are concerned, though they are not directly to be adjudicated by courts, but through the ex ante process of the regulatory mechanism under the Competition Act, CCI has been very much into that and enhancing the opportunities for the FDIs through the route of merger control. That's my limited submission.
I think we have sorry, I'll have to end our discussion today. We have completely short out of our time. I will I'm sure many more comments could have been on these questions. I would now want to invite Professor Dabidu Patna, who is our registrar and the chief proctor of Jindal Global University, to give his closing remarks. I'm sorry, Sridhar, I've kept you waiting. The discussions were just very interesting.
Thank you so much, Aviroop. It's indeed my pleasure and delight to be part of these conversations. I'm a lawyer too, but I work on other areas of law, in particular international and comparative law. So it's been a great deal of learning because we knew the impacts of various areas of law, even within the subject of law and even on other disciplines, which is in fact the artifact of the conversation this evening, wherein we have lawyers and even economists discussing certain significant areas like developments in relation to digitization and the digital India policies of the government of India. But certainly it's a paradox again because the way COVID 19 had impacted all the developments that had taken place. Because on one hand, we do have situations wherein online education, online medical services, and even the other areas have progressively and positively developed. While there are challenges, overall within the particular sector. So we are so happy and glad that JIRICO took up this initiative to have this focused group conversation, bringing in experts from diverse areas of law and economics. And we also hope that there's going to be a report on the conversations conducted this evening that could feed into the ongoing work of the Competition Commission of India and even various other bodies of the government and also the non-governmental agencies and think tanks and law firms to collectively pull in the thoughts and to develop some ideas on these areas. And JIRICO deserves to be complimented as always for conducting discussions and for bringing out research papers. So I take this opportunity to thank the leadership of JIRICO in particular for this initiative that includes all my colleagues like Ashish, Indranath, Aviroop, and Vishwas, and the list goes on because the team also expanded for the kind of research work that they are bringing in and even the reports that they have been producing. But certainly, we are also grateful to all the participants who joined us this evening in this discussion, and we are grateful to Dr. Geeta Gauri, the former member of the Competition Commission of India, for her contributions to the conversations this evening, but also to the university in particular. She has been a great friend and supporter of our activities. And we are also grateful to Ms. Payal Malik, the advisor, Competition Commission of India, for her acceptance and for her contributions to the dialogue this evening. And we are also glad that Professor Daniel Sokol from the Florida Levin College of Law joined us at this dialogue this evening, notwithstanding the time difference. And likewise, we are glad that Mr. Manas Kumar Chowdhury from Khaitan and Company, another collaborator of the university, who joined us at this conversation, and Dr. Anuj Kapoor, an economist in the room from the Indian Institute of Management, for his delightful contributions to the dialogue this evening. And we are also thankful to Ms. Sangeeta Singh, who moderated the discussion along with Avirup this evening. The conversations could go on for some more time, but nonetheless, there are so many ideas that cropped up during these conversations, which could become a point of departure or feed into the future dialogues that we are going to have. Thank you all very much. It's been a great learning experience.
Thank you, Professor Patnaik. And with this, I thank all this, and I think it was a very fruitful discussion. I have many more questions, but we could keep it for the next time. Thank you all very much.
Thank you.
Thank you, Aviru. Thank you, Sangeeta. Thanks. Bye.
Thanks.
Thank
Bye.
you.
Thank you. Bye.
Bye.
Bye.